Good morning, and welcome to our virtual probate seminars. We talk about probate court, and we'll talk about estate planning and estate administration. Just stop me at any time, and I'll throw some other things in there too. Hopefully everybody survived the last hurricane well, and I know there's another one bearing down on Florida. And I've got one sister in Naples and one in Ponte Vedra, so they're preparing for that one. And I think school down there is already out from Monday through Wednesday for some of them. And so generally, as indicated, I'll talk to you about probate court, estate planning for every family, a little bit about elder law. We touch on our court. We also handle civil commitments. Mental illness and alcohol and drugs affects all our families. Touch on that. We'll talk a little bit about guardianship and conservatorship. We actually want to avoid that. Avoid guardianship by the healthcare power of attorney and avoid the conservatorship by the use of a business durable power of attorney and or a trust. And I'll give you some points to ponder, some trivia, try to make you smile at least today. Anyway, here's all the different divisions that we have at probate court. And I'll touch on each of these. Here's an organizational chart that will help you. And if we start with those doing estate administration, if we look over to the left-hand column, you'll see that we've got 5 estate clerks, and each one of them, you'll see has 2 ending numbers. And so from there, if you look at the ending number of your case file, you'll know which estate clerk is helping you. You look down, Lindsay has 4 and 9, Felicia 3 and 8, Nicole 2 and 7, Sharon 1 and 6, so on. So just keep that in mind when you're probating your loved one's estate. And we find it best that one estate clerk help the families from beginning to end. And if they happen to be out on vacation or lunch, the others can also help. Anyway, we do about 2,200 estates a year. At any one time, we have about 3,500 open. So each estate clerk has about 600 or 700 open files, and they stay open depending on the length of the probate. And we'll get more detail into that shortly. Commitment and guardianship division. Again, we do involuntary commitments for alcohol and drug and mental illness. We do about 18 to 1,900 of those a year. And guardianship and conservatorship, we have about 1,000 of those cases open. And then I started some problem-solving courts to help those involved in the criminal justice system. We hope people will get their help voluntarily. If not, we got the civil commitment. And then if they get involved in the criminal justice system, then we have these problem-solving courts to help. Okay. And over on the top right, we have the marriage license division, our happy division, and I've got a program called Love that I'll explain to help. We do about 7,000 marriage licenses a year. And then we have court staff, we've got some law clerks, and I've got other judges also. And here is a direct directory where you can get directly in touch with the individual that you need help with. And as you can see, they'll have numbers down there, sometimes 2 numbers if it's their cell number, if they're working remotely, working from home. We hate for you to have to go through our switchboard. And so that's why we give these direct dial numbers, because I hate calling a place and having to go through a switchboard. You can get directly to the individual that needs to assist you, and you'll see their email address there also. And we are here to help you. Now we're located down at the 4 Corners of Law. If you see the new, the historic courthouse just been renovated. The outside has, and we'll be moving back in there in the near future. We're currently located on the bottom right, which is the Blake Tenement Building for our state division. Our commitment division, marriage license, guardianship, and conservatorship is in the brick building on the bottom right. For the Blake Tenement, you do have to enter that brick building to get back to the Blake Tenement. Anyway, it's the 4 Corners of Law. We've got the mayor's office on the bottom left, our historic courthouse on the top right. On the bottom right, our federal court on the top right, in the highest law, God's law. All right, if we were in person, I'd be giving out a candy bar to who can tell me who named it the Four Corners of Law. What great legal historian? Last name starts with an R, first name with an R. Anyway, it was Robert Ripley. Ripley's, believe it or not, if you remember our comics in the local newspaper, used to have a picture of the Four Corners of Law. This is Mrs. Ripley I met now, and threw that in there because we met her at one of the functions over on James Island. Anyway, the historic courthouse is on the right. You can see it's been refurbished. On the left is how it used to look. It used to be the state capitol before it moved to Columbia. It was done by an Irish architect. Here on the right, a man by the name of James Hoban. You see the picture there. He's got the Leinster House and a portrait behind him. On the table there is a model of our courthouse. On the left there is a bust of George Washington. When Washington visited our city, he liked the work that Hoban had done and had him bid on a number of projects. And one was the White House. So Hoban ended up doing the White House. And you see the White House on TV, remember it's a Charlestonian that did it. And the left there, we're dedicating a monument over in Hoban's hometown in Callan, Ireland. And that's my son there, younger days. Luggage didn't make it, so he had to buy some plaid pants, and not quite sure what to do with the Irish girl. All right, some other trivia trying to make you smile. What's the highest basketball court in the land? I saw where yesterday LeBron James got to play basketball with his son, Bronny. First time a father and son duo in an NBA game. Highest basketball court is above the U.S. Supreme Court, of all places. I've been up there. I made 2 shots. You can't shoot while they're in session, but that's where the highest basketball court in the land is. This was my mentor and Jamie's mentor, also Morris Rosen. He passed about 10 years ago. He was very much a Southern gentleman and always treated everyone with respect, from the janitor to the judge. And we try to model our behavior off of the role model that he was. Always have somebody advocate for you. My mother passed about 3 years ago. This picture was taken a year before she passed. And at that time, she'd recently been in the hospital, and the hospitalist said it was time to let her go. We couldn't get her comfortable. Her back was bothering her, and she was screaming at it. But we said, no, her mind is sharp. And we had a doctor from the outside come in, gave her an epidural, and she lived another year. I've always wanted to send this picture to the hospitalist. Here she is at her grandson's wedding in the church where she had been married. So that's a special photo. So always have somebody advocate for you. We'll look at advanced directives. It's amazing what medicine can do. And you've got to decide what type of quality of life you want. But my mother passed about a year after this picture, and the weekend before she passed, she actually was out shopping. So shows you that you can live a full life, and just make sure you have somebody advocating for you. Estate planning. Let's talk about this for every family. We don't want your will to look like this, one that was actually presented to the court. We've changed the names. We never know when God's going to call us. Will has to be in writing, has to have 2 witnesses, and then signed at the direction of the testator. Looks like my list here over on the right going to Costco, and then you never know when God's going to call you. So you can see that this will actually met the requirements. To make a will, it's less than making a contract. You have to generally a 3-part test, know the objects of your affection, generally know what you own, and generally know who you want to leave your things to. There's no requirement that you leave anything to anyone. A surviving spouse does have a right to what we call an elective share, but they have to file against the estate. And that's generally 1/3 of the probate estate and 1/3 of any revocable or trust assets. All right, let's look at 11 things I'd have you consider. One is that you want to start your probate your estate planning with a checklist. The lawyers will have a checklist for you. If not, you can use one that I presented here, and I'll show you in a little while how very important it is to get to an attorney. Keep in mind some of these documents here overlap. And so the attorney will help you decide what's best for you. On the checklist, we want to learn a little bit about assets. One is probate assets. Those are controlled by the will, or if there's not a will, by the intestacy statute. Basically, the state legislature has written you a will if you don't have a will, and that basically goes according to your family tree. So you want to have a will, and it would control those probate assets, or if you don't have a will, then the intestacy statute will. Other assets could be non-probate assets. Generally, they're controlled by a third-party contract. Best example may be a joint account with right of survivorship. When one tenant passes, the surviving owner then takes the entire asset. Real estate used to be what we call tenants in common. Husband and wife each own 50%. Nowadays, it's joint with right of survivorship. So just keep that in mind. And it brings up an important point. Ever how you own your assets, you want to pull out the source document, because many times we think we own assets a certain way, and then we look at the source document, the deed or the bank statement or the life insurance policy, see how it's owned, and see who the beneficiary is. You can accomplish your estate planning through non-probate transfers, but very important to know where your assets are going. And an attorney will help you with that. And a checklist with your source documents will also assist you. If we look at number 2 and at number 6, we talk about a trust. A trust is a vehicle where sort of like a separate entity that can hold assets and protect those beneficiaries that might not be able to handle the money. The most common example would be a young child. If they have a conservatorship here, when they turn the age of 18, they're entitled to whatever in the conservatorship. And many times we're turning over $50, $75, $100,000 to an 18-year-old, and we can only hope that they invest it wisely and spend it wisely. One way to protect that child is through a trust, and maybe give them 1/3 at 25, 1/3 at 30, 1/3 at 35, so they learn along the way. Of course, you would have powers to invade for health care or for school or college. Most restrictive I've seen was a child couldn't get the money until age 65, but that I think those parents wanted to make sure that she was a spendthrift, that she at least had Social Security at that age. Anyway, get with your attorney and they can assist you. So we want to have a will, and we can have a will like number 2 and have a trust inside of it. And that's called a testamentary trust. If we do number 6, we have put all our assets in a living trust. The attorney will also have you do another will called a pour-over will, which basically says everything that I haven't put in my living trust, I now do so at my death. So we always want to have a will, and we always want to have a trust. And it's your decision making whether you want to put it inside the will or put it outside. If you own property in a number of different counties, a number of different states, then yeah, it's advisable to do the revocable living trust. If that's not the case, sometimes the administrative cost of setting up the revocable living trust can outweigh the benefit of just doing a will and inside that will having a trust. But that's all personal choice. The person in charge of the will is called the personal representative. Used to be called executor or executrix. Now we have a version of the Uniform Probate Code, so it's called personal representative. If you're named in a will, you generally don't have to post bond. If it's an intestate estate, no will, you may be required to post a bond, basically an insurance policy that you as personal representative are going to do your job. There'll be a background check on your credit check, and then you post bond based on the personal estate, which is generally 1.5 times the value of the personal estate. And does not include the real estate unless the real estate is sold. Any questions on a will? Any questions of what kind of gone over so far? Stop me at any time. Or you can put it in the chat box there if you don't want to unmute. Okay. Or if you want to raise your hand, I don't know if I've muted everybody. I muted some, but I can unmute you if need be. Okay. The third is the financial or business durable power of attorney. This allows me to point a loved one. I can point my wife to pay the bills if I'm incapacitated. If I'm battling one of my 15 kidney stones, she can still pay the bill. Power of attorney to be effective has to be recorded. It's the one document that has to be recorded on this list, and that's recorded at the Register of Deeds office. Power of attorney is where you appoint somebody as your agent. They pay your bills, taking your money, and they can handle your assets as if they own them, but they're under a fiduciary duty to handle them for your benefit. Very important to choose somebody that you trust. Powers of attorney are not regulated, not supervised, so very important that you select somebody that you do trust. The power of attorney can be limited. Many times people have a power of attorney just closing a real estate transaction. They're going to be out of town and they can do it that way, or they can have a very detailed power of attorney. Number 4, their healthcare power of attorney. As it indicates, it covers making your healthcare decision making. It's not necessarily end of life. Number 5, that declaration of desire for natural death is dealing with more end of life. Healthcare power of attorney is, as it indicates, you appoint an agent who makes those healthcare decisions for you. Again, it does not have to be recorded. It does need 2 witnesses and a notary. It is a statutory form, so it's right out of our code of laws. So it's the same for everyone in South Carolina. That helps our medical personnel, our doctors, our nurses see the same document each time. Any questions on the healthcare power of attorney? Next is that living will. Again, it gets confused with the living trust. The living will is of the person. The living trust deals with assets. So it can be confused. Question is, do I need to have a will, a trust, and a power of attorney if I want my underage kids to get money after I pass? Yeah, I think you need all of these, most of these documents. You definitely need a will. And yeah, I would advise some type of trust, probably inside the will, and then a power of attorney. But the power of attorney is that somebody of majority age has to be the person that serves as your agent. Yes, definitely these first 4 or 5 you need, and then we'll look at the 5 wishes in a second. Again, the healthcare power of attorney is the same for everyone. It has where you can put maximum care, maximum treatment, or you can withdraw care. It also references number 5, your living will, which is your statement concerning your desire for a natural death. Young lady by the name of Nancy Cruzan, she was in an automobile accident, ended up in a ditch with water, lost consciousness, did not have oxygen to her brain. She had indicated that she did not want to be kept alive by heroic means. It was not in writing, it was only verbal. Went all the way up to the U.S. Supreme Court. They said you can withdraw life support, but it needs to be in writing. So that's why we have a declaration of desire for natural death. I talked earlier about a revocable living trust. Person in charge of the trust is called a trustee, and the takers are generally the beneficiaries, and it can act as a will substitute. You can also have somebody over your trustee called a trust protector, but your attorneys can help you with that. The decision you need to make is whether you want a trust inside the will or if you want a revocable living trust, and you want to get a quote on what it's going to cost for each, and then make a decision based on that and based on your desires. Number 7 is 5 wishes. It is a national document. You can Google 5 wishes. A nonprofit out of Tallahassee, Florida, called Aging with Dignity. There are 2 certainties in life. One is taxes, the other is death and dying. And they're trying to just get Americans to talk about death and dying and making those provisions so that your wishes are carried out. Anyway, you can Google the 5 wishes. You do need to watch it. Sometimes 5 wishes will take the place of the living will and the healthcare power of attorney. So look at that and go from there. somebody indicates that the brother and another family member own a house and they'd like to take his name off, how would I do that? If he hasn't passed, you'd have to get him to agree to take his name off either for consideration or as a gift. But I'd have you talk to your attorney. You need to check with him to see if he will take his name off. Hopefully that answered the question. If not, just put another question in that chat box. Number 8 is a do not resuscitate order. I lost a brother about 4 years ago to cancer. He'd indicated he didn't want to be kept alive by heroic means. He knew the cancer was going to take him in a matter of days. 2 doctors then had a DNR order if he had a heart attack, just to let him go ahead and pass. So keep that in mind. We got to decide what quality of life we want, and it not only helps yourself, but helps your loved ones. Along the same lines, we have the physician's order for life-sustaining treatment, or in some states called a medical order for life-sustaining treatment, being piloted over at Roper St. Francis at the cancer unit. And keep in mind that these kind of overlap the other documents. So take a look at those. Organ donation, I'll talk about that shortly. And then the safe cremation law. How many are choosing cremation over a typical burial? And that's just a personal choice. Keep in mind, Michael Jordan here, his dad, James Jordan, was killed in North Carolina. His body was dumped in a rural county in South Carolina. They didn't have space to keep him, and so they ended up cremating the body of James Jordan, not realizing it was Michael Jordan's dad. We did not have a safe cremation law. Our state and many states then passed a safe cremation law requiring due diligence to locate family before a body is cremated. It also has provisions. If you decide that you want cremation, then you need to get with your funeral home director, do a pre-need authorization, or put it in your estate planning documents. The 5 Wishes has a place where you can indicate you want cremation. Cremation is less expensive, and more, talk to the funeral homes, about 55, 60% indicate that they, that's what their business is. When 30 years ago, it was very rare to have a cremation. Ran into this guy flying in from Maine. Being cremated is my last hope for a smoking hot body. Try to make you smile today. I know it's tough after you lost a loved one. First estate I did was my dad's estate. And I was in law school with the help of an attorney. And I know emotionally it can be hard, but we're here to help you. Some British humor, maybe make you smile, hopefully. I got a buddy that's British, and so I threw that in there. If you think I should pull it out, tell me. But if not, maybe at least made you smile. I was leaving my office late one night and almost got run over by a guy going the wrong way. He was in the back of the car. He waved to me, I waved to him. And that's the closest I've gotten to royalty. It was Prince, now King Charles, when he was visiting Charleston 30-some years ago. And they were taking him out of the Dock Street Theater, and Church Street, as you know, is one way, so they went the other way. And I wasn't anticipating that, but I got to wave to royalty at that time. If you want to help others and eliminate the administrative costs, the Coastal Community Foundation, which is now celebrating its 50th year, is the organization for you. It'll take away that administrative costs of having to get a CPA, a tax attorney, to qualify with the South Carolina Tax Commission with the IRS. And you can have directive giving there. So consider the Coastal Community Foundation. One of their first grants was to the Center for Heirs Property, and the center, which is now located up on Rivers Avenue, Opportunity Zone. They can assist you. They do wills clinics. They help heirs clear their title. And with the help of the late Reverend Clemente Pinckney, we've got this right of first refusal. So before an heir sells to a developer, the other heirs have a right to buy the property. Anyway, and they not only help locally, pretty much all of the eastern seaboard of South Carolina. They also have expanded to other states and assisting other states to set up a center for heirs property. And their next will clinic to be announced. You can see a number there if you need to call and make an appointment. And I think, Jamie, what do they charge? Like $50, I believe, don't they?
Yes, sir, they do. $50.
Okay. It's not totally free, but they do will free clinics. But if you make an appointment and go to their office, I think it's $50. Thank you. If you're looking for an attorney, one way to select an attorney is through Martindale Hubbell. It's a free service. It lists all attorneys around the country and by their location and by their specialty. It gives their academic credentials and it also gives a peer rating, A being the highest. So take a look at martindale.com for selecting an attorney. The other way is, of course, talking to friends and family. You want to get an attorney that practices in your area. South Carolina Bar also has a lawyer referral service. If you cannot afford an attorney, we've got Charleston Pro Bono Legal Services. You can see the qualification criteria there, and we can send all these slides to you. And there's also South Carolina Legal Services and another one called Charleston Legal Access, which basically charges on a sliding scale if you don't qualify for one of the others. The American Bar Association always is stressing mediation, and just throw this one in here. If your family, if you have a dispute and want to resolve it short of litigation, this mediation can be very helpful. We talked earlier a little about organ donation. You can see the number of people waiting for an organ. The late Dr. McMahon has started this Donate for Life SC. And they have another number of forms there that can assist you and educational videos. And we can do it on a driver's license. You can do it on your estate planning documents, or you can do it on these types of documents that he has. I haven't been to Italy, but this California family unfortunately lost their son there. They donated his body for organ donation. California did not have a program involved like that. And this family, it's called the Nicholas Effect, ended up changing the culture there in Italy and now has organ donation. Elder law, let me just touch briefly on this. We've got these various topics here that you see, and I would direct you to the Palmetto Project. They can help you with Medicaid, Medicare, private insurance. It's a free service. They're located up on Rivers Avenue. They also, if you don't want to go into their office, they can come to your home, and they're partly funded, I believe, by the United Way. Every district in South Carolina and around the country, this Trident Area Agency on Aging has a wealth of resources to help us as we age. And I would direct you to their website, the Family Caregiver Support Program, excellent program to give you a break if you're caring for an elderly parent or cousin. We also have Department on Aging, and they have information also. We're looking at, I think this is going to be rolled into a different agency, but right now it's Department on Aging. If you're looking for, if a bank, many of the banks will not be the trustee unless it's over $1 million, and Family Services, local nonprofit, will help you with fiduciary services, whether it's conservatorship or whether it's personal representative or rep pay. You can see the services they provide. They're located in North Charleston. Our veterans, that's this VA caregiver support line. Anyone here a veteran? If not, if we're in person, we'll send you one of our challenge coins. Appreciate your service. And here's another service that make you aware of. Kir Yaya. Yaya means grandmother in Greek. This is a individual, I think, out of Raleigh, Durham, that started this. It's here locally with the College of Charleston. If you need somebody to help you care for an elderly person, They have vetted and trained College of Charleston students to come over and be a caregiver. I'm not sure exactly what the rates are, but you can take a look there. And we always recommend everybody take a ski vacation. Any skiers here? Raise some hands. Right. And not water or snow, but spend the kids' inheritance, as we always recommend. You never know when God's going to call us. We're all worried about our bills, but we also need to take time and do what we like to do. And it may not be travel; it may be helping a son or daughter or cousin with their first home, with their wedding, with any bills that they may have. Enjoy the money while you can, while you're alive. And then I always tell the young people that be nice to their parents. They can set up what's called a pet trust. And if you have a pet that you want to set that up for, we've had 2 dogs here in Charleston County who got $900,000 in trust. We had another dog on Kiowa that got a home. And usually after the pet pass, it goes to the SPCA. Anyway, about 3 years ago, South Carolina passed a law recognizing pet trust. Let's talk briefly about wills, probate, and estate administration. I know, and I'll have more detail at the end of this, some of these slides. In South Carolina, for probating an estate, 3 ways: summary, normal, or contested. If it's less than $25,000, no real estate, you can do a summary proceeding. Still will fill out an application, but you can open and close on the same day, 30 days after a person has passed. Generally, again, it's no real estate. Usually it's a personal item or bank account that's left. Normal administration, majority of our cases generally takes 9 or 10 months. In the state administration, normal administration, we give notice to what we call interested persons. And interested persons include those people named in the will. They're called devisees. And those people that would take, if there's not a will, called heirs. And then the third interested person would be a potential creditor. And we give notice to creditors by publishing in the newspaper. And we do that once a week for 3 consecutive weeks. Well, they have 8 months to come forward from that first publication. And so that's why it takes 9 or 10 months to do that normal administration. Our contested cases are fewer, but this is where you have notice and a hearing each step of the way. It involves more of the court or judge's time. You can start with a summary proceeding and then realize you have real estate and you have to move to normal. And then from normal, you could have some type of contest and move to the third part. So you can see you can move in between these different ways to probate an estate. I'll get into more detail at the end. Any question on estate administration? This is just a quick overview. And if you want, I can show you some detailed forms. All right, what's a laughing heir? Everybody wants to be a laughing heir. You want to raise your hand. This is when you lose someone you didn't know. And then all of a sudden, like this Mount Pleasant, I looked 30 years for a laughing heir. I finally found one. He got a check from a relative's estate out in the Midwest. He didn't even know. He called the attorney, make sure it wasn't a hoax, and then also asked when the next check was coming. So you never know if you might have a family member you don't know and they leave you money. Question is, at what point do we need an attorney in estate administration? Generally, if you have real estate, you want that person to help with the real estate. Our clerks cannot do the deed. I think you'll need to sit down and with one of our estate clerks and see if they can assist you. If you have a complicated estate, number of different assets, then yeah, and if emotionally it's difficult to handle the probate, then I'd always strongly recommend using an attorney. Attorneys generally charge on an hourly basis, but they can assist you. Most attorneys will tell you, whether just to go to the probate court and we can help you, or whether they think they need you to help you. So that's a personal choice that you'll have to make, business decision. Question was about bankruptcy. Boy, if they were in bankruptcy at the time of passing, I'd have you get with an attorney on that, um, generally, just so you know, if you're the personal representative, you don't personally owe the debts that the decedent owed. You just have a duty to, safeguard them and marshal and properly distribute them. But if you got an estate that's in, individuals in bankruptcy, I'd have you talk to the bankruptcy attorney. Question is, if I buy additional assets, do I need to update my will, trust, power of attorney? Generally, you want to review your estate planning documents each year, particularly if you have a change in family circumstance, a divorce, a remarriage, and a child. If you collect additional assets, you want to follow the advice of your attorney. If he has it in a revocable trust, he may have you put that new asset in a revocable trust, but I'd have you talk to your attorney during the estate planning process. Hopefully that helps. Okay. Then and now, you used to have to come down to the court to do your state administration. We now have this easy filing, and you can e-file anywhere. You see, we're now open 24/7, accessible for the public and attorneys anywhere in the world except North Korea. We're working on that. And we're the one court where you can go to one of our local libraries and they would assist you. Jamie is also working with Dennis Robin to get us into North Korea. Trying to make you smile. Anyway, it's a $7 fee. And it's a one-time. It covers the entire probate process, so you don't have to pay additional fees each time you file documents. There may be probate fees associated with the size of the estate, but this is just a processing fee. And you'll find our easy filing. Again, as I indicated, you can go to any of our local libraries and they have scanners and they can scan in to the court here the documents that you need to file. You scan and basically email to one of our estate clerks. And even I can do it. I visited one up in Otranto in North Charleston, and here I am probating estate. And the librarians are all glad to help you. And as a side note, if you haven't been to one of our local libraries, I'd strongly recommend it. They've been refurbished, upgraded, and they're beautiful facilities, and they have a lot of family, or not family, but community rooms. And we go over there and make presentations. Question is, once probate is closed, is it final? I know someone was left off the probate document and she was told about it over 10 years later. Generally it is final. We'd have to look and see if notice was given to everyone. If there's some type of fraud that may toll the statute of limitations, I'd have you check with the attorney on that. I'm not sure if that answered the question. Let me see. Yeah, can I explain guardianship in probate? Guardianship, probate court has jurisdiction over adult guardians, family court over minor guardianships. Guardianship is when somebody becomes incapacitated and cannot make healthcare decisions for themselves. If we have somebody in an auto accident, they end up down at the hospital on an emergency basis, we appoint a temporary guardian to make decisions for them. Now, if they had a healthcare power of attorney, they wouldn't need that guardianship. Guardianship is of the person, conservatorships of the assets. So if somebody is incapacitated, mentally cannot make decisions about their money, then we would appoint a conservatorship. And if they couldn't make decisions regarding their health, we would appoint a guardianship. And that would be a guardian. The other one would be a conservator. Person under a guardianship is called a ward. Person under conservatorship is called a protected person. Sometimes you'll see people use them interchangeably. Guardian of the estate in some states would be our conservatorships, and guardianship of the person would be our guardian here. Hopefully that explains that. But that's why you want a healthcare power of attorney that would avoid that guardianship of the person. The business power of attorney would avoid the conservatorship, and or a trust would do the same too. Was that good? Let me see. You've got somebody that the parents passed in the last 5 years, not sure what they owned. You can do some searches. If you don't have money to hire an attorney, I probably would go to the Center for Heirs Property or Charleston Pro Bono Legal, and they could assist you to start. I would highlight, and I think we've added a slide, but this treasurer's unclaimed assets, everyone should take a look there. You may have paid a bill or had something with health insurance, and you'll be surprised they send it strictly to the state treasurer. So always look up your name on that South Carolina Treasurer's unclaimed property. That's where I would start, and then I would start with an attorney, either at the Center for Heirs Property or at Charleston Pro Bono. The going rate for a guardian SC these days, a guardian is generally charged by the hour. It depends on their whatever their expertise is. Generally, I think we start at $60 an hour and go up to $125 an hour, depending on their experience. 125 generally is somebody who's well-versed, experienced. They may have also passed the Center for Guardianship certification. They may be a member of the National Guardianship Association. Anyway, guardians is a very tough job. It sounds like a lot of money, but you're on duty, on call, like you are for your parent. It's 24/7. And so guardians generally charge on an hourly basis. Conservators generally will charge a percentage of the assets. And generally it follows what a bank would charge, bank trust department. Hopefully that answers that question. If not, type some more. What are we seeing in the court? We lost at Charleston 9. I grew up with Billy and Randy Hutchinson over in the playground. Many of them believe that getting a will was bad luck. And so that's why we are trying to make sure all of our first responders have access to making a will. Very important that everyone have a will. A couple other questions. Good. And Jamie just typed in the treasures thing. And we'll make it into one of our slides because I'm amazed at how many people are on there. But I think many people find it a way, many businesses find it a way, instead of trying to track somebody down, they'll send the $100 or $200 or $50 to the state treasurer. The state treasurer will also indicate if it's under or over $100. Yes.
Hello, Judge Condon, can you hear me?
Yeah, I can hear you. Go ahead.
Hi, I'm Madeline Smith. I am a new attorney with South Carolina Legal Services.
Oh, good.
So I've been hearing around the office some, I guess, complete frustration with finding court reporters
Okay.
related to probate matters. I was wondering if you have any recommendations or if you know why this is becoming an issue.
Okay. Yeah, I think I know why it's an issue. It's just so everyone knows, for any of our hearings, we can either record it or we can have someone called a court reporter there that takes everything down. You've seen on TV and the court items on TV, you've seen a court reporter there taking everything down. Our court reporters, many of our hearings are shorter, and for them to time they come down here, drive, park, and everything, that's the issue we've been running into. Is that it's not long enough for them or enough money to justify coming here. we're trying to work through that, and we're trying to work through that with scheduling. So that if we have a court reporter come down and we've got 3 1-hour hearings or trials, that one court reporter does all 3, not 3 different court reporters. So we are working through that. And if you want to call me, we can discuss further, or I can give you a call about how we're trying to resolve that issue. Some courts have on staff a court reporter. That is not the case we have here. The other thing we're doing is we do a lot more virtual hearings, and that cuts down on the need for a court reporter. We do them on Zoom like we're doing here. If they're generally uncontested, we won't need a court reporter, and we can just do the recording on Zoom. So that's how we're trying to solve that issue. It's basically just a supply and demand. If they're doing depositions, those are longer all day, and they can make more money than coming to do an hour or 2-hour court hearing. Now, if we have a week-long trial, there's generally no issue there. Hopefully that helps.
Thank you, yes.
Yeah, sure. The Emmanuel 9 were murdered right downtown here. They showed us that love conquers hate. We had no violence in Charleston. At the funeral, late Reverend Clemente Pinckney, the president, was there. Reverend Pinckney was in the middle there, and he was instrumental in getting that right of first refusal. Those in West Ashley, on the top right is Cynthia Graham Hurd. She was a librarian. The library west of the Ashley is named after her. Football started up, and Clay Matthews was a boxing coach over at the Citadel. Had many family members go to the NFL. They had to reform their trust. My son's always trying to collect autographs, and I told them they needed my autograph to change their trust document. This Charlestonian won the Masters back in '38. Keep in mind, he had lost a son who'd come to see him playing a tournament. He had a hard time dealing with that. His attorney wasn't aware of that, so make sure you tell your attorney everything in your family situation. They had to come to court later and amend the will and the trust, their plan, to include the children of the deceased son. So very important that you tell on that estate planning checklist everything that relates to your family. Shoeless Joe Jackson, we have this hill, Shoeless Joe's Hill, over at Riley Park here in Charleston. Big display up in Greenville. He was illiterate, didn't sign many documents. He did sign his will, and to a baseball collector, that will was worth about $75,000 with his signature on there. The residuary beneficiary charity actually sued the probate judge to get the original document. It went up to our state Supreme Court. They said that original documents stay with the court. So just keep that in mind if you're famous. It'll be with the court. The countess that started Spoleto used a local attorney. Not sure how she found that local attorney, but it may have been through Martindale Hubble. You can name your trust in your will or outside your will. Any name. James Brown's trust still in litigation over in Aiken. It's called the I Feel Good Trust. Marriage licenses, again, we issue about 7,000 of these a year. About 2,000 are from out of county, so we're making our county additional money. We have a program called Love, which is live, online, virtual e-marriage application, and assist families. They can apply anywhere. License is good only in South Carolina, and there's a 24-hour waiting period. Jamie threw this one, and so it begins. I don't like the tone of your I do. Just trying to get everybody to smile a little bit today. You'll see individuals that you see on TV come through our court, and everybody's coming to Charleston to get married. And we're very good with our signage. You can see marriage license division over on the right. You'll see commitment division. So good with our signage here. Let's talk a little bit about civil commitment. Again, we want people to get treatment voluntarily. Mental illness, alcohol and drugs affects all of our families. Hopefully they go voluntarily. We have the Charleston Center for Alcohol and Drug, and we have the Charleston Dorchester Mental Health Center, and we have our hospitals. If they won't go voluntarily, we have our involuntary process. And if they're involved in the criminal justice system, we'll have one of our problem-solving courts. Just trying to get people the help they need. Again, our civil commitments, we're now doing these hearings. One of the good things that came out of the pandemic is we realized we could do these hearings virtually. That way we don't have to shackle and bring down to the courthouse our family members. We can do these virtually. And we do it at the different courthouses. Different hospitals, they are closed to the public. Because we want people to get the help they need. We have many facilities here in Charleston, and all can assist our family members. Again, we've got a new Charleston Center up on Rivers Avenue, and that deals with alcohol and drugs. There is some move to combine the Department of Alcohol and Other Drug Abuse Services with the mental health. That may come down the road. For those veterans, we appreciate your service. We're honored that the local VA and this ship was named after Ralph Johnson, a Charlestonian, jumped on a grenade in Vietnam, saving his comrades. And we have the other facility on the bottom left up in North Charleston. So for those veterans, you can get the health care you need. And this Live Oak just opened up right up there by Trident on the other side from the interstate, but another beautiful facility to help those with mental illness. For those who lost someone to overdose, there's always this annual remembrance. Keep that in mind. For those, we're all struggling with the effects of fentanyl. Nancy Shipman lost her son Creighton. She started Wake Up Carolina just to keep people aware of the need for overdose prevention and for Narcan training, and they have support also. They have free Narcan training. Next one you'll see is Wednesday, the 9th at 6 p.m. Everyone should have it, even particularly those who have seniors in the house. I know my mom had a pill reminder box. Sometimes those pills can get mixed up. So it's very important that we all get trained on Narcan. And they'll give you a certificate after you complete the training. Just talk a little bit about commitment papers, the involuntary commitment process. Again, if a person's a danger to others and themselves, we're blessed with a group called Mobile Crisis, and they can go out and check on individuals and assist them in the community. The process generally is we appoint an attorney. The attorney looks after their legal rights, guarding ad litem after their best interest. We have 2 designated examiners. We have a hearing. And our role as a court, as a judge, is to make sure they get the best treatment in the least restrictive settings. And you can see what the results are. It could be inpatient. Generally, it's outpatient or a combination of both. And I won't go into those details. We've had some high-profile cases that y'all may remember. If you do have a commitment or a guardianship conservatorship, we almost had a Sandy Hook over here at Ashley Hall. I had done a civil commitment on Alice Boland. She still possessed at that time the right to own a firearm. With the help of those parents, that law has been changed. And so if you have a civil commitment, you don't have a right to have that handgun and be reported to NICS. And I saw this down at Tulane University. We don't know how people are doing, so it always says seize the awkward, reach out to others. And there is help. We've got a suicide crisis lifeline. We've got mobile crisis that can come out and help you in the community. And we've got too many veterans we're losing each day to suicide. And there's a special veterans crisis line. And with our civil commitments, we're using the tools of our problem-solving course, like drug court, mental health court, to keep track of those under civil commitment order and to encourage them, whether it's an incentive such as a small gift card, because $10 gift card from McDonald's can go a long way rather than 2 or 3 days and $1,000 a day at a hospital. So our hospitals have graciously donated some incentives so that we can carry out these functions to help our citizens stay involved in treatment. And again, if they're involved in the criminal justice system, we've got the adult drug court, juvenile mental health. Judge Goldstein here started the first drug court down in Miami. He was a Brooklyn cop turned lawyer, turned judge, and they had a terrible crack cocaine problem down there and started a drug court. I went out to Seattle, and Judge Goldstein actually came up and helped us start ours here. And I went up to Seattle with Judge Casey, and we were able to start a mental health court using the tools of drug court. They had lost a retired fireman after a Mariners baseball game. Was killed by a civil commitment patient. So we're trying to get people the help they need. Judge Russell, we met at a conference, started the first veterans treatment court up in Buffalo. He was not a veteran, and nor was I. And we started a veterans treatment court here in Charleston. And I've got a veteran, Marine veteran, now heading up that court. And we have incentives and sanctions to change behavior, generally use incentives. There also are program requirements. One here is Brian is graduating. He has to pay restitution back. When you're under drugs and alcohol, sometimes you don't know what you're doing. And he broke into Chief Mullen's house. Think of any house to break in the city. He broke into the police chief's house. Chief Mullen was up at Clemson. I think he's now retired. Anyway, Brian is doing well and paid the chief back for the things that he had stolen. On the far left picture, you'll see Judge Brucey Hendricks started a federal drug court. And she runs an opioid task force, and they can keep track of where the overdoses are taking place. So if there's a bad set of drugs out there, we can try to notify people to be extra careful. But this one pill will kill is also a very important reminder of the power of fentanyl, and we've got to end these overdose deaths. People asked about conservatorship guardianship. I'll touch on this a little bit more. Guardianship, again, is dealing with medical issues over the person. And we always try to get a limited guardianship, give people the greatest powers or rights. We believe in independence in America. So we may have a guardianship or conservatorship, but a person will still retain many of their rights. We just want to protect them from other people taking advantage of them. Plenary would be a full, and that's rare unless a person is fully incapacitated. Again, conservator, basically a manager of the money of a person, of their assets. Again, the guardianship and conservatorship of the use of the healthcare power of attorney, respectively, the business power of attorney or trust can be avoided. And their manager. There's more detail there for you. And then for reporting purposes for conservatorship, we require an annual accounting with a bank statement. Our background checks includes a credit check when they're applying for a bond. And the bond is also an insurance policy that the money is still there. We also check on our wards under guardianships, our seniors and our incapacitated adults. We've got a program. We are one of 2 courts in the nation selected. We're selected with Maricopa County. And we've been running this program for a number of years. And I train students over at the law school, and they go out in teams of 2 and check on our wards, our seniors, doing a wellness check, a monitoring, and assistance to make sure they're okay. And then we have the National Center for State Courts. We're one of 2 courts selected for that. And we did it with Detroit, and we were doing a rapid response conservatorship program, just checking expenditures in real time. Okay. And we have a number of advocates for seniors, vulnerable adults. You'll see here each town either has elder support in the mayor's office, or they may have it at the police department, like Mount Pleasant does. Here's another item I'd have you write down, smart911.com. It allows you to sign up and give your background information so that if EMS, a doctor or nurse are coming to assist you, they will have background information. You can give them your medical history, your next of kin. You can list your pets, any concerns you may have. Anyway, take a look at smart11.com. It's a free service. And so sign up today if you're in Charleston County. And again, we do these workshops, and if you can't sleep at night, I've got some recorded. Jamie's recorded me. We don't provide the the popcorn, but there are, sometimes people like looking at the state administration workshop and they can go to the part that they want to know about. Anyway, I'll walk through each of the forms there. Does anyone have any questions? That's at an hour, and I've got some other information I'll run through here shortly. Again, our next one is November the 4th, and we do these virtual workshops. I started them when I first was elected, and we did them in person. And the beauty of the pandemic is that we can do these virtually. I think the furthest I've had away is somebody from Alaska that joined us. So I don't know if anybody's further than Alaska. I'm trying to get to somebody in Hawaii or somebody in Europe joining us, but I have to see. Here's my ski trips. My son doesn't know I'm spending his money. St. Andrews up at North Charleston, Fenway Park. And then we took my wife and we went out to Seattle. Anna Cockrell on the top right. So happy she finished third in the Olympic trials, so she got to go to Tokyo. And this past year she ran in Paris. And then we made it to Ireland and gave him a portrait of James Hoban, and had a wonderful time there. And last summer we went down to Panama. My dad had served in the Army in World War II. His job was to protect the Panama Canal. I didn't realize it, but it was actually built by a South Carolinian named Gilliard, and about 30% of our 40% of our ships coming into Charleston Harbor go through the Panama Canal. Very lucrative. It's like $1 million to $1.3 million to go through the canal. It's like a $5 billion business. That's interesting seeing the canal down there. I got to add my 2024 to give you that. Anyway, sample estate file. Any questions? What we've gone through so far? Got to be some questions. Anything in particular you want me to highlight? And I can walk through the different forms. Everybody want me to continue? Or are y'all gonna tell me what you would like? You can type in the chat box, continue, or if you've got questions, you can type in the chat box. Jamie, we doing okay?
Yes, sir.
Yeah, okay.
Someone said to continue, sir.
Okay. I see that's you. No, I'm teasing.
Oh, yes, they all want you to continue. Yes, sir.
Okay. I didn't tell them about jokes in a courtroom. What are the 2 rules about jokes in a courtroom? Who's been in the courtroom, right? It's 2 rules. Number 1, only the judge tells the jokes. What's rule 2? No matter how bad the joke is, you have to laugh. Okay. That up there. Let's talk about estate administration. And what I have and what's been sent to you is just a typical file. And here's an estate index. Again, we have an overview of the process I stated earlier. The role here is to get the assets from the decedent to the rightful takers, whether it's under the will or whether it's under the intestacy statute. Keep in mind, if there are non-probate transfers, they would not be part of this estate administration. They may be listed, but they would not be part of the estate administration. And we're trying to give notice again to 3 groups. One are the heirs, those that would take if there's not a will. We give notice to devotees, those named in a will, and we give notice to creditors through the newspaper publication. Again, it's all administrative process. If no one objects, then it goes through without any issue. Okay. What is the index? The index really is just a summary of the probate process. I'll go through each of these documents. So we start, if you look at the top there, with a death certificate. And if we have a body, we'll have a death certificate like this. If we have an accident and a body is not recovered, we may need some other report, or we may need to come to court to prove of death. We had a small plane crash off the coast here. I had a hearing on that, determined that the death occurred at that date. They had reports from the Coast Guard that they found an oil slick. They had reports from the FAA of the plane going off of the radar. So we would take testimony in that regard. We had two boys that drowned on Folly Beach. They found the body of one, not the other. Took testimony there. We had a sailor get in an accident at the jetties. Did not find a body. So, and we would have them declared deceased on the date of that accident. Another way is if you go missing, you can be declared after a period of time. It used to be 7 years. It's now 5 years. We had a man hop on a plane here, go to Atlantic City, was never heard from. One of those unsolved murders. The family was able to come in and testify after that period of time, after the 7 years, it'd be 5 years now, after 7 years, that they hadn't heard from their dad or their husband, and that every Christmas he sent Christmas gifts, every Mother's Day he did something, every birthday he did something, so showing that he was missing, and then he could be declared deceased. Generally, we do have a body, and that's where we get a death certificate. Okay. Someone wants to know the exact cost of a will, trust, power of attorney. It can range from $500 up to a couple thousand to $5,000 or $10,000, depending on the size of the estate. Generally, I think you're looking at $500 to $1,500. It just depends on the complexity of your estate. Remember, you're the consumer, so you can shop around and ask. You want to get somebody that you trust and that you have a long-term relationship with. And remember, your kids, they can, for your birthday, Mother's Day, Father's Day, Christmas, they can pay for your estate planning. The attorney's duty is still to you. So you want that peace of mind. That's another way of doing it. Ms. Smith, you have any comment on what the expense of a will, trust, all would be?
Not currently.
Yeah. I hate that I'm not more specific. Most charge, some will charge a flat fee, some will charge on an hourly basis. Okay.
Judge, would it be prudent that anyone may call the Bar Association?
Yeah,
Is that
yeah, that'd be one way you can call and ask. And that's the same with all the attorneys. You can call and ask them what they generally charge.
if it's okay, Judge, I'll put the number down to the Charleston County Bar and the South Carolina Bar. Would that be okay, sir?
Yeah, that'd be good.
Yes, sir. Thank you.
You can put it down for all the different organizations and they can check. Yeah.
Yes, sir.
Okay. Anyway, we start with death certificate, and then 30 days after a person has died, you're to deliver the will to the court. Then 30 days after your appointment, you'll do a form called information to heirs and devisees. And then 90 days after your appointment, you'd fill out an inventory and appraisement. And then about 9 or 10 months after all that, you'd be looking to close the estate under normal administration. Here I'm going under normal administration. Generally, we would have a will, and freeze up on me this morning. Here we go. I got one moving. Trying to get it to move. Doesn't want to move. Anyway, we're going to start with an application that says here. We got another question. Let me see what that's Jamie putting. TV wills that are on TV. Please do not use one of those. Kind of get what you pay for. I strongly recommend not using those. If Condon's department store was still in business, I would say not to buy a will kit. I don't think we ever sold will kits, but if we had one, I would tell you not to buy it. Go to an attorney. The peace of mind is worth it. Go to a South Carolina attorney that does wills and probate, or one of these other, like the Center for Heirs Property, they can assist you. When we start the probate process, we'll fill out what's called an application. We'll provide the death certificate, provide the will. And if you have an application, if we look about a quarter of the way down, it'll be on the left side there. If we had a formal action, it would be called a petition. And so a lot of this is self-explanatory. We fill it out. And then on the next page, we list under 4A, the devisees. Those are people named in the will. 4B are those who would take if there was not a will. In the example I have here, I have dad passing away, survived by mom and 4 kids. Of the 4 kids, 2 take under the will, 2 do not. So that's why the other 2 are listed under 4B. They're not taking under the will. But in the example, all examples, we still have to give them notice. If we think of this logically, individuals need to have notice of what's transpiring. People live across the state, across the country, across the world. They may not know a loved one has passed. So we give them notice, because arguably the 2 children, if there was going to be a will contest, they would be the ones that would contest it. So we have to give them notice of that. And I'll show you shortly that information to heirs and devisees that we give them notice from. And you indicate the original is attached. You sign this verification. I'll note that on this verification, at the end there, you indicate in that paragraph under verification, you hereby submit to the court's jurisdiction. So if you live out of state, you're submitting by signing this to our court's jurisdiction. And we would sign if there's a will, an informal probate. Either way, we would sign an informal appointment, whether it's testate or intestate. You will sign this qualification statement of acceptance. You may remember our parents and grandparents would actually come in and be sworn into the office of executor, executrix. It's now called personal representative. Well, in the old days, everybody, I want y'all turn your cameras on if y'all want to. Let me see if you can raise your right hand so I can see if we got an honest group here today. Anybody want to turn their cameras on? Show me the palm of their right hand. Let me look. Ms. Smith, thanks for. Anybody else want to play along? Okay, yep, we got 2 honest people. Want to see any other honest people? Want to show us their palm of their right hand? Okay, we can put them down. Yeah, we got 2 honest people here. In the olden days, if you're dishonest, they take a red hot poker and send you a mark in the palm of your right hand. So I did another. Okay, good. Everybody's honest today. I did have a case where a guy took the stand. He had a mark on the palm of his right hand. He had a construction accident. I had to ask him about it. Anyway, yeah, this can be completed online. Jamie, we've got it where the question was, can it be completed online? I was thinking we had this, and whether we're taking electronic signatures.
Yes, sir. You have the slide that expounds on the e-filing system.
Okay. All right. Now
I
that
can
one,
always send that to that individual so that it,
yeah.
I see it's Miss Terry. Miss Terry, I'll send the information to you.
Someone asked about going forward. And they want to charge you $4,500. I would start with Charleston Pro Bono, Charleston Legal Access, any of those first, before you know what it's going to cost you. Yeah. Hopefully that helps. Anyway, so we bring the will, the death certificate, we complete the application. And you'll get 2 receipts, one to open the estate, generally a nominal fee, and the other is for the publication expense. And you'll choose which newspaper you want to publish in. And you can see, Jamie will need to update this. I think the Moultrie News just went up on their price. So that'll be $40. And you can decide which newspaper you want to be in. And I'm working hard. I've always been trying to eliminate costs. So we bundle these and we get a bulk discount for running the estate creditors notice in the paper. But the newspapers have blocked me. I've been trying to get it where we can just do it electronically online. Maybe someday we'll have that. Fiduciary bond, I've been talking about this. It also applies to an estate. A bond is just an insurance policy that the personal representative will do the job that they signed up to do. And again, it's calculated on just the personal estate, 1.5 times that value. Does not include the real estate unless the real estate is sold. You can waive bond, and in 999 out of 1,000 cases, it's fine to waive bond. Generally, we have, mom appointed, and the kids agree to waive bond. Here's a renunciation of right to administer. Not used in my example here, but I wanted to show you this. If you're named as the personal representative, and for some reason you cannot serve, you can renounce your right to serve. You can also nominate someone else. Of course, under will reading, we can't jump over the alternate named in the will. We follow the testator's intention. So we'll name that alternate. You can also nominate someone, and you can also waive bond. And bond many times is waived. Right. And you'll get a person in charge of the estate. It's like a separate corporation person. It's called the personal representative. You would get what's called a certificate of appointment. This is what the banks, brokerage firms, people you're doing business want to make sure you are the person in charge. And you can also show them your fiduciary letters. Again, I talked earlier about the time frames. 30 days after a person has passed, we need to get the will of the court. 30 days after appointment as personal representative, we file this information to heirs and devotees, letting everyone know that a probate has taken place. Again, the heirs in our case were the 2 kids not taking under the will, and then the 2 that did take under the will. And of course, mom is the PR, so she's giving herself notice. You give a proof of delivery, basically an affidavit to the court that information has been sent to those that are required to send it to. 90 days after your appointment, you fill out what's called an inventory and appraisement. Again, you'll see on that recap there, non-probate assets are optional. Many times they can be more valuable than the probate assets. Probate are listed to the right, and you'll see, and there'll be supporting schedule for each one. I will highlight one thing. The one time the federal government is good to all of us is at death. It gives us what's called a step up in basis, a free step up in basis. Let me try to explain that. If I had bought a piece of property, say 30 years ago for $10,000, and today it's worth $100,000, if I sell it today for the 100, deduct basis my cost that I paid for it 10, I'd have a $90,000 reportable income. If I let it go through my estate, it then goes to my wife. If she sells it a day after I die, she gets a free step-up basis to the 100,000. So then she sells it for 100, deducts her basis step up of 100. She has no gain. So very important to work with your CPA, your attorney, in putting these values down. Sometimes real estate is in a ballpark, and putting it in a higher value can actually assist you. Again, you'll see real estate listed here. You'll see supporting items. Real estate for the longest time, again, was was tenants in common. And you'll see that on the first item. Real estate nowadays is primarily a joint with right of survivorship. So consider that. Let me see, I got some questions here. Thank you, Jamie, you putting those in there. Yeah.
And Attorney Smith has provided information for her office, legal services, South Carolina Legal Services.
Very good, thank you. Good, good, all looks good. Anyway, you've got supporting schedules for each of those items in the inventory. Again, you just really have to list the probate assets. You'll see some non-probate assets listed here, but that's just to give you an example. After you file the inventory and appraisement, you will get a bill, and it's based just on the probate assets, does not include the non-probate. It's generally in South Carolina, it's $95 on the first 100,000 of probate assets, and then a fee after that. Our fees are relatively inexpensive compared to New York and California. And you'll get a receipt for what's paid. Here's an example of affidavit of publication in the newspaper. They'll send it to us. Once you decide which newspaper you want, we've got to send it to them. It has to run once a week for 3 consecutive weeks. So that's why many times it can take about a month to get it back to you. Okay. Here's a statement of a creditor's claim. You want to let the health insurance run its course before you pay any of the claims. And you would want to wait to the end to make sure you have all the claims. I say wait till the end, wait till that creditor's notice is expired. It's 1 year from the date of death or 8 months from the first publication. Okay. And if you're the PR, personal representative, we're looking for you to handle that claim either by paying it, compromising it, or sending a notice of disallowance. We just want some proof before we close the estate that you've handled that claim. And here's a notice of disallowance. So again, you can pay it, you can compromise it, or send a notice of disallowance. The creditor can actually petition for allowance. They do have to pay that filing fee of $150. So many times creditors wait to the end of the probate before they see what they're going to receive. Again, here's an order related to an allowance of claim. When you get ready to the close at the end of the estate, you'll need to file what's called a deed of distribution, and you'll see a copy of it there. Again, it can be given to the probate court. It's filed over at the Register of Deeds office. Doing a deed is considered practicing law. Somebody asked me earlier, when do I need an attorney? Definitely need an attorney doing your deed of distribution. Again, you want to wait till the creditor's period is expired, and this is how you give property to whoever the taker is. Basically, the personal representative is giving up their right to that property. Again, there's 3 ways to close on a normal administration. One, if you're the sole heir, sole devotee, you only person you need to give notice to is yourself. We'll take a look at that document. If there are other heirs and devotees, you can send the standard closing documents, which are 1, the notice of right to demand a hearing, the accounting, the proposal for distribution, and other receipts and releases. Again, number 3, say mom's doing the estate, all the kids can file waivers without having mom do the closing documents. So there's always great flexibility in the probate code. Just keep that in mind. Here's a verified statement. You're the sole heir, sole devotee. Basically, you're stating you've done your job, given notice, paid the creditors. So here, close the estate. Typical standard closing documents would be an accounting where you show what you started with, your receipts, and on the back you give some detail. You're just letting the interested persons know what you did. Here's what I've done. And if you want to object, you've got this notice of right to demand a hearing. Here's a proposal. I'm not sure what I have. I still have it. This is who I plan to give it to. And if we get somebody to take an item, we want them to sign at least a receipt. We prefer a receipt with a release with waiver. That way they're waiving their rights to challenge what you've done as personal representative. And waiver of all the 3rd way, the kids could all sign a waiver of statutory filing requirements. And that way mom doesn't have to complete the accounting and those other documents. If she does complete the other documents, we got this notice right to demand a hearing. Basically, it says, I've done my job as personal representative. Here are the closing documents. Please indicate, if you want to challenge, you've got 30 days. And you'll file an application for settlement. And you'd send, as you see here, the proof of delivery is only the 2 kids that were takers. The others had their chance to challenge. And so this affidavit, we've given the closing documents to the individuals. The estate clerk will diary it and wait 30 days. If nobody objects, then they'll have an order closing the estate. And once the estate is closed, it can be reopened if you find additional assets. You can do what's called a subsequent administration, and it doesn't reopen the creditors period, but it allows you to get reappointed so that you can handle that asset that you've now discovered. If you get behind on filing any of these documents, just let us know. Please send us something in writing. We have a motion for an extension that you can complete and find that, or just an email or a letter. We just need something in writing. I know it's difficult with the loss of a loved one, and we've got attorneys and others that can help you probate that estate. But if you do get behind, we'll send you a reminder letter, and then we'll send a second reminder letter, and then the third, it may actually be a court hearing. We don't want that. We're here to help. But court administration's on top of us, making sure we want to make sure we do have our estates up to date. Questions, concerns, comments? And here's my direct dial number if I can ever help you, and my cell. Questions, concerns? I know I've kept you about an hour and a half here. Yeah. Jamie, did I miss anything?
Well, sir, you have that one experience, the young man who visited your court, if you want to share that with
yeah.
everyone.
I'll leave you with one. See if y'all can answer this one. Individual comes to our drug court. Of course, going through the court, you got to go through security. Down at security, they've got scanners. They have you empty your pockets. He emptied his pockets, and lo and behold, he had drugs in there. They took him into custody, brought him up to me. What was his defense? Ms. Smith, you might be our legal person here today. What would his defense be? They're saying it was his medication. Nah, these were illicit drugs. But good try. He said they were not his. He said he had borrowed the pants. The pants were not his. We gave him an A+ for creativity, but we got him some additional help and treatment. If I can ever help you, let me know. I'll kind of like that one. Oh, I got my screen. Any questions? Any other comments? Enjoyed having you. You can come back, or you can watch the recorded one too. And
Judge, I have a question.
Sure.
I'm the executor on my fiance's will, and I'm the sole getting everything.
Okay.
I think I missed the part that you were talking about. I'm not sure if you answer it, but I have 2 kids, not from him, from my previous marriage.
Right.
And if I pass before the estate is done, settled, is it all going to go away? He has an ex-wife but doesn't have any kids, and he choose not to leave anything for his sister and brother. So is it easier for me to, no matter how much it is, because I see about 4,500, to get a lawyer? And can lawyer continue to do it? Or the second executor, if I cannot do it, is the ex-wife, which we are sure that not going to do what she's supposed to. So that is like, in my mind, he has one house and have some stuff in the house that we are trying to sell and pay his hospital bills. When I add everything together, it came to around $19,000 with the home insurance and home warranty and everything, taxes.
Then his name? Yeah.
His name is Bratcher Taylor.
No, I meant the amount of money in his estate is what, is under 25,000?
No, because he has a house worth
Okay.
around $280,000.
Okay. Yeah, I would have you get with an attorney. if something happens to you during his probate administration, the new executor or personal representative would be under duty to follow his wishes, which was all to go to you. So it would go to you, and then you would control it under your will, or if you don't have a will, under the intestacy statute. So it's still coming to you either way, if his will says everything is left to you.
Okay. Okay, so without the lawyer, if I pass, then the second executor will take over and whatever left is going to come to me. Is that right? Or to my
That is
estate?
correct. Whoever the alternate is named
Uh-huh.
would take over the probate, and then it would go to you. That's correct. And it would go
Okay.
to your estate if you have passed.
Okay. I hope I won't yet.
No, let's not plan on that.
Yeah. Thank you.
Sure. Other questions, comments? Anything I can help you with? Well, I appreciate you taking the time to join us today. Again, I know losing a loved one can be difficult. We're here to help. I've done my dad's, my mom's, my brother's estates. Emotionally, it can be hard, but we're here to help you and try to make what can be a difficult situation at least pleasurable to come through the estate administration. Jamie, thanks for your help again today. And if you have any questions, give me a call. You've got my numbers, and I'll be there for you. Okay. Thank you. Y'all have a good day.
Thank you, Judge.
Thanks.